Mr. Chairman, and again, I thank the witnesses for your testimony, and this raises a number of questions in my mind as I listen to their response. I'd turn first to Professor Collett, and would you assert that there existed a conscience protection for medical practitioners prior to the passage of Obamacare?
Well, certainly there's the Weldon Act and the Hilberton Act that protected both medical institutions as well as individual practitioners in certain instances.
And is it also your understanding that the passage of the Patient Protection and Affordable Health Care Act has struck that language of conscience protection and allowed for an executive branch to essentially impose obligations on healthcare practitioners that go beyond that conscience protection that you've cited?
Actually, Congressman, I believe that's an issue that is being litigated as we speak on behalf of a number of both individuals and religiously affiliated institutions. I do believe that they will be successful in their litigation because I do not believe that the Secretary of Health's regulation will withstand constitutional scrutiny.
Thank you. And I'd turn to the Very Reverend Catherine Hancock Ragsdale and ask if you agree with, at least philosophically, with conscience protection for medical practitioners.
No.
You think they should be compelled then to provide sterilizations, abortifacients, and contraceptives even if they object to it on religious terms?
You know, I'm a church person. I believe in conscience. We're big supporters of conscience. We believe that everyone's conscience should be respected as long as they pay the price for it. Civil disobedience, if you're willing to pay the price for it. Conscientious objection, if you're willing to pay the price for it. But if you're not willing to shoot people, don't join the Army. If you're not willing to carry a gun at all, don't become a police officer. If you're not willing to experiment on animals, medical research probably is not the place for you.
Well, let me then ask the question.
If you're not willing to provide full medical care, don't go into
I'm sorry, the clock is ticking, so I do get your point. And let me then ask the question, if this conscience protection then apparently, if you're willing to pay the price. And so in your testimony you talk about assisting a young lady, and you state that you don't believe that you violated any laws. But you also assert, if I note this testimony, that you have no choice because of your oath and your commitment. And you say, I have no choice. Even if you tell me it is a crime to exercise my ministry, I will have no choice, and I assure you I am not alone. So are you saying to this Congress then that if this legislation passes and you're met with a similar question for an individual that you describe in this testimony, that you would cross the state line, you would violate federal law, you'd be willing to go to jail for a year or pay a $100,000 fine if you believed it violated your conscience to fail to serve?
I hope to God I would have the courage of my convictions and my faith to do that.
Do you believe that a judge should have a conscience protection?
I beg your pardon?
Do you believe that a judge should have a conscience protection?
A judge should not have to uphold the law if he disagrees with it?
Let me just suspend this a second. I would like to turn to Professor Collett, and then I'll come back to you on this. And Professor Collett, I'll tell the narrative here, and that is that the parental notification law that was passed in Iowa, I was part of, that the gentleman, Mr. Nadler, asserted or discussed. And I met with judges around the state, and I can think of one in particular who expressed to me how troubled he was that the law required him to provide for the judicial waiver, the judicial bypass, I think as it was referred to. And he was greatly troubled because of his faith, because of his convictions, but he found himself a sworn judge required to carry out the law, and now, because of the language in the law, he was required to provide that judicial bypass, even though it violated his most profound moral and religious convictions. Do you believe judges should have conscience protection?
Congressman, this actually came up on the Texas Sub-Advisory Committee on drafting court rules for parental notification and parental consent in that state. At that time, we determined that it was appropriate for a judge to recuse, as they can on any matter where they believe their personal values will not allow them to render a judgment under law.
And Reverend, is it your position that not to recuse, or would you apply the same philosophy to the judges as you would the medical practitioners? Either pay the price or leave the profession and find something else to do?
Well, you understand I'm not a legal expert. Recusal sounds like a reasonable alternative to me, but I haven't given this a lot of thought.
But if you would allow a judge to recuse themselves, wouldn't you allow a medical practitioner to recuse themselves as well?
Medical practitioners have a responsibility to respond to the emergencies in front of them. If there's another doctor handy that you can hand off to, that's fine. If not, it's your job to provide medical care.
Thank you. There are very few pregnancies that are emergencies. I yield back.
Thank you, Mr. King.